Joining us today is Associate Professor Philip Mendes from the Department of Social Work at Monash University. He'll be speaking at IIR's National Juvenile Justice Summit, which takes place on the 9th to 10th of March 2011 in Melbourne. Hello Philip, thanks for joining us.
Good morning, James.
Local and international research suggests an overrepresentation of young people leaving state out-of-home care in the youth justice system. Why do you think this is the case?
Look, I think it's a combination of pre-care, in-care and post-care experiences. What we find is that young people that end up in the youth justice system tend to be those who've come from particularly disadvantaged backgrounds in terms of socio-economic status and often have experienced quite severe abuse and or neglect prior to coming into care. Then, when in care, many young people don't have the most consistent and stable care experiences, and what often happens also is that those who, let's say, have the most difficult behaviour dynamics end up in residential care rather than foster care, and that can exacerbate their existing situation by meaning that they don't get consistent and stable support from particularly supportive adults. They often get involved with other peer groups within residential care who are involved in criminal activities. There can be a fair bit of anger and resentment towards the state care system. There may be drugs involved or mental health issues involved, and sometimes also young people who are in care are more visible to corrective authorities. So, for example, if they perpetrate minor offences like damaging a window of a neighbour or of the residential setting where they're staying, that can lead them into court, whereas that may not happen for mainstream young people. There may also be issues around the adequacy or otherwise of legal support for them when they come into that youth justice system. So again, there may be a whole lot of reasons why they're more likely to have contact with the system and more likely for that contact to continue and potentially end up in a custodial order. The other issue is when they leave care, there may be a lack of ongoing support for them. They may not have a supportive adult, family member or otherwise to help them in that transition from care. They may not have wider supports in the community and extended family like most young people in the community have. So what we are picking up from the existing research is that many of them appear to graduate straight from the out-of-home care system into youth justice and often into custodial sentences, and the youth justice system becomes a de facto state parent for them at that point.
To what extent have leaving care plans and policies addressed and minimised the involvement with youth justice?
To the best of our knowledge at the moment, very little, whether we're talking Victoria or any other state and territory, but we are currently undertaking a pilot study with White Lion in Victoria looking at the interface between leaving care and youth justice, and we are getting the impression from initial interviews that when care leavers are involved in the youth justice system, at the point of leaving care, whether that be a community order or in custody, that often the responsibility for the substitute parenting of that young person is simply transferred to the youth justice worker, and child protection sees active involvement. So what we're trying to find out in the White Lion study is a little bit more about the dynamics of that handover, but certainly that is the impression we're getting, that youth justice tend to take over responsibility more often than not at that point.
How can the ongoing role of post-care youth justice address personal disadvantage, particularly when young people are in custody at the time of their exit from care?
What we've found from looking at the UK system, and I did a visit to the UK in April this year and talked to a number of the key people in leaving care in both local government and central government and the NGOs, was that they have an obligation under their leaving care system for a personal advisor to maintain ongoing contact with young people even if they're in prison until they're 21 years old. So that personal advisor keeps contact with the young person. They will review and update their pathway plan. They maintain regular contact with them either in person or by phone or email while they're in prison, and they particularly ensure that suitable accommodation is available on release for those who are in prison. So the roles of the respective workers in the UK seem to be clearly defined, and they've just released a very detailed report by the Department of Education called the Children Act 1989 Guidance and Regulations, Volume 3, Planning Transition to Adulthood for Care Leavers, which has a 5-page chapter on ongoing support for young people in youth justice. So I think the general message from there is that it's important that all workers with these young people, whether they're leaving care workers or youth justice workers, keep focusing on the care issues as well as the offending issues, and keep attempting to address the childhood experiences of trauma that clearly have an impact on the offending behaviour.
What is the current availability of preventive practices and policies to reduce the number of care leavers involved in the youth justice system?
Again, in Victoria or elsewhere in Australia, none that we particularly know of, but that is an aim of the research with White Lion to try and find out more about whether there are any preventive social and educational programs that are either available at the moment or could be potentially introduced to assist this group of young people. So particularly in the area, for example, of promoting better family relationships, that could be an important strategy to try and minimise that link between leaving care and youth justice involvement.
You're speaking at IIR's National Juvenile Justice Summit, which takes place on the 9th to 10th of March 2011 in Melbourne. What other key aspects will you be discussing in your presentation?
We will be talking about the findings of our current pilot study with White Lion in Melbourne, which has involved interviews and focus groups with both a number of White Lion workers and young people aged 18 to 25 who have experience of both the out-of-home care and youth justice systems. So the goal of the study is to examine that interrelationship between the child protection and youth justice systems, and particularly to explore the processes that take place when young people involved in the youth justice system leave state care. So we're aiming to do 4 things. We want to examine the availability of targeted preventive social and educational programs to assist that group of young people whilst they're still in care. Secondly, we want to examine how the formal leaving care plans and policies that are applied for every care leaver in principle do address and minimise involvement with youth justice. Thirdly, the role, if any, of formal consultations with youth justice by child protection regarding that particular group of care leavers. And finally, the ongoing role of youth justice post-care, particularly when young people are in custody at the time of their exit from care.
Philip Mendes, many thanks for your time today.
Thank you, James.